It's always that weird, awkward time until, you know, it lets us know we are actually live. And I do see us. Wonderful. We are live for Making Awesome Season 2, Episode 3, with a good buddy of mine, Mr. Brent Britton from CoreX Legal. Brent, if I could do an intro for you, but I know you're going to give me a much better one. So if you can give me the Backstreet Boys, the who you
You
are,
mean
the
you mean
word.
I'm better at talking about myself than you are?
You might be a little
No one
bit
who knows
better.
me would be shocked by this.
Yeah.
Uh, Hi, everyone. I'm Brent Britton. I'm a co-founding partner of a law firm here in Tampa and San Francisco, California, called CoreX Legal. We specialize in business law, which means we don't do a lot of litigation, although we do some of it. Most of our clients are technology startups. We have a lot of clients who are entrepreneurs and they're not particularly technology. We have a lot of technology companies who are no longer startups. Most of our clients are technology startups. I've been practicing law for 28 years. I graduated law school in 1994, which is like a million and billion years ago. Right at the dawn of the web, guys. It was like, there was like William Tell Overture was playing. It was very peaceful. It was just lovely. And then business happened and people started selling domain names for $500,000 each. And then it got worse from there.
Yeah. What a missed
But anyway,
opportunity.
yeah, I know, right? Listen, I was in grad school and we were standing around, a bunch of us were talking, and someone took note of the fact that, so this is 89, 90,
Uh-huh.
possibly 91. Procter and Gamble
Mhm.
had went out and registered a bunch of domain names like soap.com and tide.com and cheer.com, and they were free at this time. You could just go register a domain name and that was perfectly fine.
Right.
Procter and Gamble had gone out and registered all of their trademarks as domain names, and we were all like, what on earth could this mean? I mean, what a strange move for a company like Procter and Gamble, because mind you, at the time, the internet was populated by MIT.edu and NASA.gov. And that it was just a bunch of science geeks on the internet at the time. So anyway, I've been around for a while on the net. I was on the internet before it was called the internet. As a matter of fact, I first logged into a computer that was connected to what was then called BitNet, and the University of Maine in 1982. And so anyway, been around for a while. Been practicing law since 94, same practice for the most part. Full spectrum legal for the technology startups. So we will do corporate formation and venture funding and co-founder agreements and governance documents and all the things that you need to pack into a company to make it look right. Look right for whom? Well, for investors, for employees, for other people who are going to be taking a look at the company at some point in the future. See, the whole point of most of the legal work that we do for a startup company is to get it ready to be sold.
Right.
Or get it ready to be invested in, right? So we want to make sure all the documents look right and say the right things and exist and are available and in a vault somewhere, a virtual document vault. And we do patents and copyrights and trademarks and all the intellectual property, and we do licensing and we do agreements of all stripes. So we do, independent contractor agreements and vendor agreements and joint development agreements and patent licenses. And basically, if you're doing a deal and you're writing it down and putting it on a contract, by goodness, we can paper that puppy up for you and think strategically about it and all the other things that need to happen. We do employment and labor law to a certain degree. You're representing companies, so naturally we need to tell them how to treat their employees and how not to treat them badly and all the other things. And as I say, we do a smidge of dispute resolution, breach of contract disputes, trademark infringement disputes, employees who are doing wrong things. We can represent a company in matters like that. And we're just here to, have a good time and help people. Because here's the thing, starting a company is hard enough. Being in business is hard enough. And you shouldn't have to reinvent the legal stuff every time you do it, right? One would think that the knowledge of what I do would be in the drinking water by now. Mm-hmm. But no. So we try to be this adjunct sort of general counsel's office where we can just be there and why we can help those startups out. Are we in trouble? You look troubled.
No, we're good. We're good.
Okay. All right. You're maintaining our signal.
Oh yeah.
Hello, Swindon. Can you hear us?
No, it looks, we're still good. I'm just making sure that everything is clean.
You got us on your instruments?
Something like that. Yeah.
You got us on a tuba, perhaps?
More of a trumpet.
A trumpet. Okay. Still a valid instrument. Yeah, anyway, that's me. That's my history. I'm just this guy.
Just a guy. And talk to me about CoreX Legal.
Right. So we started CoreX, a partner of mine, Greg Karch, excellent lawyer. We've worked together in the past. Greg has deep, deep knowledge of crypto law and how that works and how it should work. And he and I got together and launched this firm on April 1st of 2020. And it wasn't an April Fool's joke, it turns out. So we got a great team. We got 6 or 8 associates. As I say, we have one guy in San Francisco. We're looking to grow that office. I have my eye on Boston. I need an office in Boston. 2 of my alma maters are in Boston, MIT and Boston University School of Law, and they actually do things together. Like the Media Lab does things with BU law students about how to help startup companies. And I'm like, well, damn it, I went to both of those institutions. I'd love to be involved in that party. And of course, Boston turns out nice place to represent technology startup companies. CoreX is, we have a goal to be the technology law company, a firm, in the country, if not eventually, potentially globally. I'd like to grow the firm to be a powerhouse. I'd like it to be the Morgan & Morgan of technology startups. And I got mad respect for the Morgan & Morgan firm. I mean, if you get injured or get in a car accident and something that's not your fault, who do you call? You call those guys. I mean, they get her done. So I want to be the guy you call, the firm you call, when you're thinking of a software license, or thinking of some kind of intellectual property pursuit, or thinking of starting a technology company, or thinking of getting hired by a technology company, or doing a deal of any kind. We want to be your business lawyers, especially in the tech space. So that's our goal there. Nothing short of world domination, really, when it comes right down.
Isn't that really just the goal of every company?
I mean, I think so. I think the goal, especially in American in Western capitalism, Grant, I think the goal is to make as much money as you can and stick it in your ears and go to the rest of the world, and then I hope to give a bunch of it away. We take a very humane approach to business at CoreX Legal. We care very much about our employees, our lawyers, and their happiness. This is a tough job. It's got to be perfect every time, or you get sued for malpractice. It's a stressful job. There can be long hours. People can spend time away from their families. That's no good. We don't like that, and we try very hard to make sure that our employees are well taken care of. We give we have a nice benefits package. We have a nice vacation package. We have a nice giveaway. We try to allocate funds to all of our employees so that they can donate to the charity of their choice. And we built the firm based on a set of core values that I think we consider to be important, and we try very hard to work in harmony with those core values, and we try very hard to set process and procedure that sort of falls out of those values, so that we're not just winging it and making dumb decisions without going back to the, I don't want to say the Bible or anything, but the things we truly believe in and that we want to see happen in the world. Love, respect, kindness, crazy godless liberal stuff like that.
Yeah, who knew that caring about people's actually a valuable thing to do?
I know.
God, especially right now.
And you see this. I'm sure you've heard stories about how the person, he or she conceives of the company, forms the company, starts the company, makes the company get to a certain level of success, brings in some investors, and the investors fire the CEO so they can take over the company. I mean, that level of predatory behavior, it happens. I'd love to say it was rare, but it's just not uncommon, unfortunately. And it's just so short-sighted, right? Because I think, while it's true that most entrepreneurs don't make good big company CEOs necessarily, that's not the gene that they have. They have the startup, the startup, the entrepreneur, the wild maverick gene. They don't necessarily have the boring gene, which is running a stupid company that's huge at that point.
Yeah.
But to kick those people out is just ludicrous. First of all, it's not the last good idea they're ever going to have. They're clearly a smart person. They've demonstrated they can execute. Why would you cut that person loose? It's just so people make a lot of short-term, make a lot of decisions exchanging short-term progress with long-term wealth, I think. And I don't always think that's a good idea. But Who am I to judge?
I mean, and a lot of companies will start up a little cavalier more than others. I can't exactly say mine was not one of them. Where we just kind of operate on, hey, pay us up front, and then the work
Yeah.
gets done. And every now and then, I let a client run out a bill, and then they run off on me.
No.
And even if you have the contracts, it can be tough to collect on it. But we only do contracts for jobs north of $1,000, simply because under $1,000, nobody wants to sign contracts.
Yeah,
And I
well,
can,
yeah, no, it's tough. Look, we in the law, we have a mandate to try to do free stuff as much as we can, right? I mean,
right.
it's part of the code of conduct for lawyers is that we do as much pro bono work as we can without starving. Or at least a reasonable amount. And so, yeah, look, people call up and they want to talk to me for 5 minutes, and sometimes it turns into 20 minutes. And, if you equate that with a billable hour, that can start to add up after a while. But I'm really trying to just do more of that stuff where I just pick up the phone and talk to people or send them a quick email without worrying about charging them. Because like yourself, if it's not going to hit the $1,000 mark, it's not worth me opening a new client and going through the rigmarole, the
Yeah.
paperwork, all the other things. But also, when we do move into meaningful work, I really insist on getting paid in advance nowadays. I've chased too many clients for too many years, many of whom didn't even, they weren't stiffs, they meant well. It's just that we racked up a bill that was unexpected or bigger than they'd hoped or whatever. And so then we have to work on payment plans and stuff like that. And unfortunately, like yourself, my job is how I feed my kids.
Yep.
So if you're not paying me, then we're in the wrong relationship right there, because my kids are so hungry. So,
And it feels kind of dirty from the business side, right? Because from my perspective, you have stolen from me, right? And from their perspective, it's like, I'm not paying, you go to hell. There is a disconnect between when you don't pay your bill, you're quite literally taking food off of my plate, because that is money that goes into paying for things. And I'll tell you, there are a few things that you have to pay for, right? You don't pay your car insurance, you got yourself a problem. You don't pay your car payment, they're going to come and take it. You don't pay your house, they're going to come and take that too.
who's really good at try skipping your power bill. Try letting your electric bill get over like a week old. Boy, you'll hear from them, and they have a switch with
Yep.
your name on it. So yeah. Again, one so hates to be predatory, certainly. And I don't believe I've ever asked for anything from a client that was unfair. And it's an unsavory conversation that you have to have, and you want to keep your heart open, and you want to be as kind as possible. But yeah, I mean, at the end of the day, man, I'm a professional and a good one. And if you're not interested in compensating me for my work, then we don't need to work together.
I feel that in my soul.
Yeah.
Over the years, I have learned it, right? Initially, when you start your business, it is the ideology of, if the money is there, we don't care. And very quickly you realize that is a really shitty way to run a business, because you're going to deal with some bad customers.
Right. Okay. So especially if this is one of my hard and fast rules that I have broken and honored in the breach way too many times. But the hard and fast rule is, if there's a red flag, end it. No matter how big the check they're waving in your face. If there's something in your gut that's telling you, no, they did the thing and it's not really, or there's an ethical, or there's something, just believe that voice and ignore the fancy check that they're waving in your face. And we've done this. I had a client, I think I've tried to be an entrepreneur a few times over the past several years. I've started a few companies. I've had more or less degrees of success. And we were hiring somebody at one of my startups as a salesperson. And she was excellent in every way except the one thing. And I don't remember what it was, but it was a big red flag. And we said, but she's just so good at sales. We should overlook this red flag and we should hire her anyway. And literally within a week, the red flag flew again and came back and bit us. And it was just a big mistake. So it's tough, man, but you gotta enforce that. When you see ethical problems, lack of judgment, values problems, nefarious behavior, and I'm not talking about just people being a little maverick or a little wicked or a little fun-loving or something like that. I'm talking about folks really making, significant breaches of good judgment.
Yep.
The expression is, when people show you who they are, believe them. because that won't be the last time you see that behavior. So, unless they're in therapy. All right. I mean, unless they're getting help in that case, well, good luck to you.
Hey, we always recommend good mental health around here. In fact,
Got to work on yourself, buddy. No one else going to do it for you.
we've had Johnny Crowder from Cope Notes on. You must know Johnny, right?
I don't know him personally.
Oh my gosh, he's great. He's a local. And for those that don't know, Brent is also in the Tampa Bay area, and we have Hurricane Ian, which is going to be barreling down on us in the next probably 24 to 48 hours, we figure.
Yeah, it's supposed to. We as we sit here right now, it's 2:16 p.m. Eastern Daylight Time on Monday, September 26th, and by I think 48 hours from now on Wednesday, about this time, we're expecting Ian to roll through the Tampa Bay region. Looks like it's probably in that zone to be Tampa's worst case scenario, which is just north of the mouth of Tampa Bay. So you have the rotation of the storm pushing all the water and the storm surge up into Tampa Bay, which means all of the little coastal regions that the bay impedes on, as well as Hillsborough Bay and all the rivers, are likely to see
quite a bit of water.
In fact, Zone A here in Tampa has already been ordered to evac. Zone A is the first zone right on the coast down there at zero altitude, or elevation rather. And so I personally, as I sit here, am 3 or 4 blocks from Zone A, but I'm also a good 15 feet above sea level. So the water would have to get pretty high to even get to my doorstep.
I love how we say we're a good 15 feet above sea level. Like that's a lot.
Yeah, that's a lot. I mean, a 15-foot storm surge would flood my street, okay? But my street gets flooded when it rains hard. So I'm accustomed to that. I drive a 4-wheel drive Jeep Wrangler, by the way, with 37-inch tires. So I can get through most anything. Now, the big problem, though, folks, is that when a storm like this blows through, it takes the electricity out. And our biggest pain in the butt is not necessarily surviving the storm. That's actually kind of fun. But it's dealing with 2, 3, 4, 5 days with no electricity, air conditioning, refrigeration.
God air conditioning might be the worst part of it. I mean, don't get me wrong. The losing your food can be rough, but if the storm is gone and your fridge is about to be out, fire up the grill, baby. Let's go.
Let's eat. Yeah,
let's
absolutely.
eat. Time for a party.
And we have a lot of non-perishable food in the house, and we have a gas stove. So unless the city gas goes out, if that's the case, we can use the grill.
Yeah, you're on a city water and city gas, city sewer, and all that, right?
Correct. Yeah.
Yeah, I'm out in the country. I got a well and septic.
So, you got your own stuff. Yeah. Okay. Well, so yeah, a hurricane is unlikely to take out your well, right?
Well, I mean, no power, no water.
Oh, so if you can't get the water up.
Yeah, I can't pump it out of the ground.
Pump it out of the ground. Yeah.
So yeah.
Are you filling your bathtub and all the things?
No. I got 10 gallons worth of big water jugs that we're gonna fill up and kind of ride it out. Irma, we were only out for 52 hours, and the battery bank.
52 hours.
Yeah, only 52.
2.5 days, dude.
Well, the battery bank that runs this set of printers can run all of the necessity items in this house, which is a fridge and a couple of the fish tanks, for 2 days.
Oh, that's nice.
Dead straight, not unplugging anything. And if it starts to get close to day 2, I'm unplugging the fridge for 6 hours a day. Right.
Sure.
So yeah, it's
if you don't open the door, your fridge will stay reasonably cold
for a while.
Not forever, but for several hours. I would say 6 hours is probably about the max I would trust it, because then food's going to start to turn or whatever. But and you don't want ice to melt and leak everywhere.
No, yeah. The again, it's never it's not the fire. If you have a house fire, it's not the fire that's the problem. It's the water they use to extinguish the fire that's the problem. Because water just gets into everything. So things are going to get a little crazy here, and you guys will see Wednesday's video is going to be all about some hurricane stuff. And if we do get some decent wind, I might try to recreate the Death Metal Slayer internet meme with the guy holding the American flag head banging in a hurricane. So might see if we can make that happen for you guys.
You have the hair for it.
I do now, and I'm hoping not to have it next hurricane season. So we'll see. We're gonna shave it for charity here relatively soon.
Oh, that's nice. I was hair guy in law school.
Oh yeah, you had long hair.
Yeah, I had hair down to my belt in law school,
God, it's
and
so bad.
oh, I know.
It gets so warm and it clogs. I have curly hair, so it clogs the drains. It's rough. It's
I
rough.
get it. No, I rode motorcycle everywhere back in law school too, so I had to braid it. I had to braid my hair because if I didn't, it would just go right and just be
Literally the
this, yeah,
badass law student that rides a motorcycle. Got it.
yeah, 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 yeah. I mean, I was less badass then than I am now, but I looked the part.
And we got a commenter saying Def Leppard Grant version. Here I am rocking you like a hurricane. We do have a couple of comments or questions from the comments here. We got Build on Sound asking, uh, what were things you wish you knew before you started your first startup?
Oh man, I can answer that very quickly. And that is, I wish somebody had slapped me around and taught me about market validation. Okay.
Oh my God,
Market
yes.
validation is actually, okay. So I talk about this a lot. So the best way is to proceed from my script, which is we used to do startups this way. We used to keep it secret. We used to think of an idea and we used to not tell anybody. Maybe we'd talk to a patent lawyer and maybe we'd, have an NDA with an investor or something, but we'd start a company and we'd bring people in and nobody tell anybody and we'd stay in stealth mode and we'd build and we'd build and we'd build. And then we'd launch and we'd go, do they like it? Are we getting hits? Are the customers coming? Are they swiping their credit card? And it turns out that's a really stupid way to launch a company because all of these resources and all of this effort, time, energy, and money have gone into building this concept that we haven't tested yet against the market. We don't know if anyone wants to pay for it. So now we've turned that on its head. And the first thing we do now is test. The first thing we do now is go out to customers and we say, hey, would you buy this? Do you like this? What do you think about it? Does it have the right feature set? Does it cure your migraine headache? Because if you have a migraine headache for which this is the Advil, then you will probably pay for this, won't you? And we do this experiment and we test our assumptions, okay, which is the big part of the whole thing, because we assume that people want this, this, and this, and they might not. They might want something completely different. So I wish that somebody had taught me to conduct market validation before I ever started a company. And let me give you an example. In roughly 2000, I don't know, let's say 5 or 6, I was visiting a client. I was at a big company in South Florida that you've heard of. And I was sitting with their general counsel, the in-house lawyer, and I said, hey, by the way, how do you guys maintain your intellectual property portfolio? Like, where are your patents? And meaning, where online is your database that describes your patent portfolio and all the things about it that matter? And the general counsel of large company that you've heard of said, I think Joe has some in his filing cabinets. And I know that our trademarks are with Betsy, and she's in accounting because she pays the maintenance fees. And bing, the light bulb went off over my head. And suddenly I'm Alexander Graham Bell. And I realized what people need is an intellectual property portfolio management system that allows them to track where their patents are and their copyrights and their trademarks and all the contracts that go into proving that they own these things. And they could just press one button. They could do one touch intellectual property auditing, and they could survive due diligence very quickly because anybody who wants to look at their IP portfolio can just press a button and see, look, there it is. And I thought this was the best idea since rope. And I brought some people in and we built this system and it was really cool. And we threw it at the public and people said, I don't want your fucking, pardon my Shakespeare, I don't want your gosh darn, I don't want your gall darn intellectual property management. I'm perfectly comfortable with the fact that my patents are in Bob's filing cabinet and my trademarks are with Midge in accounting. I don't need to spend money on an intellectual property management system. And it failed. And it failed because it was not validated. It was not tested because nobody gave a patootie about intellectual property management, which, having been somewhat myopically inclined at being an intellectual property lawyer, it was my assumption that, well, of course, everybody cares about what I care about. But so that's the big deal, man. That's the big trick I wish I learned is go with your gut. Okay. I mean, if you have a gut idea that you think is good and will sell, that's fine. That's inspiration. That's the eureka moment, but don't rely on your gut. Rely on the data. Go out and talk to people. Hey, if I build this, will you buy it? And you got to be careful there too, again, because you show people a picture of your baby, they're not going to tell you your baby's ugly. So a lot of, the casual, right? If you walk up to the average person or a family member or a friend or a well-wisher and say, hey, I'm thinking of starting a company to do X, Y, Z, most people will go, good for you, man. Yeah, that sounds awesome. Pass the beer nuts. There were, your spouse might say, hey, do you really want to quit your day job? But most people I think are cool with, but they will lie to you and they will tell you what you're doing is amazing until you ask them if they'll pay for it. Okay. So that's really the trick, is to do market validation, regard your startup as a scientific experiment whose goal is to determine what people will pay for that you can deliver to them.
Yeah.
And not just a judge. Because again, if you walk into an investor pitch and you say, I just know this is going to work, I just know it in my gut. Well, that's a data point.
Yeah,
okay?
I don't.
It's really low down here on the chart.
Does your gut pay me back?
Exactly. But if you walk into an investor pitch and say, I just know this is going to work, and I've talked to 100 potential customers, and I've got 57 beta users signed up who've already swiped their credit card, and I haven't written a line of code yet, but they're prepared to buy this when it's ready. Now you've got some data.
That's a little bit better, yeah. Not a massive sample size, but not bad.
Right, but a little bit, right? No, I'd rather have 1,000. I'd rather have 10,000. Take a survey, SurveyMonkey, something. Give me some data to indicate people will actually buy this when you create it. And remember again that it's not just you, although you're perfectly valuable. I mean, your time is ticking away and you're going to breathe out someday and not breathe in again. And hopefully that's a long ways away, but don't waste a second of this existence pursuing something that's just going to fail, that you haven't demonstrated to be a reasonably good chance at success. So that's you. Forget your family and your kids and your employees and your co-founders and the people who you're going to pull into this and rope into this, who are going to spend weeks, months, and years of their lives trying to pursue this gut dream of yours that isn't backed by any data. So that's the thing. That is by far the most important thing that I wish someone had taken me aside and slapped me in the face a few times. And someone tried. I'm not going to lie. Okay. On the next one, we had someone on the team who was like, well, what about market validation? And we talked to any customers, and I did the typical thing that entrepreneurs do. And I said, who doesn't love this? Are you kidding me? This was the next startup after the IP thing. This is going to be great. It's going to make $1 million. It's going to fly. And she was very insistent. She said, no, I need to talk to some people, some of these customers, and figure out if they're going to buy this. And she actually killed the project because people weren't prepared to say that no, they would pay money for it. So,
but it saved you a lot of time.
Thank you. Yes, all of us. Yes.
Which, as you stated earlier, is more valuable than money, because you can get more money.
Yes.
There is not an amount of money in the world that can guarantee you more time.
Nope. You cannot buy the clock ticking backwards. I'm sorry. It's just a one-way trip.
I mean, geez, with the Queen is no longer with us. And if you want to talk about all the money in the world, that is literally where it exists.
If medical science can't save the Queen from death by old age, then chances are we're going to meet her up. So
she did pretty good, though.
The time will come when we too have no problems to worry about.
I hope to get there, right? But the whole startup mode, last couple of years with the human malware was a thing that put me back into startup mode. Outside of we were ready. I mean, literally we were doing a burnout, getting ready to do that first quarter-mile pass. We were there. We were at the start line. Human malware hit, and right on the line, we blew our motor. We had a $250,000 take-or-pay contract for 5 years, guaranteed by one of the largest defense contractors in the nation. Signed, ink on paper, February of 2020. Son of a bitch.
Yeah.
That it's still up. And could have gone after him to pay it, right? It was a take-or-pay contract, right? I guaranteed that money. But little tiny 3D Musketeers that does not have an attorney is going to go up against the largest defense contractor in the world. Good luck. They're going to run you dry in court in the first 2 days.
I mean, maybe. You never know. We should have talked. I mean, if that happens,
I didn't know you back then.
Well, okay. But we knew of each other.
No, I didn't know of you back then.
Huh. Wow.
Yeah.
Well, I guess I just knew of you.
Oh, well, hopefully for a good reason, not a bad one.
There's a great line in Snow Crash, Neil Stephenson's sort of seminal novel, which at some point somebody asked, so what is this thing, a virus, a drug, or a religion? And the response is, what's the difference?
You ain't wrong there.
Yeah, yeah, yeah.
So we've dealt with a lot of intellectual property concerns in the 3D printing industry. And I'm not just talking about the inventors that are the Dale Gribbles of the world.
Mm.
I'm talking about designers, 3D modelers that might do, one-off pieces. They might do fan art, and they have issues with people uploading their files to free repositories. They have problems with people uploading them to their own websites and then also charging for them, but charging less than the original creator does. And DMCA takedown requests are effing dangerous because they require, at least here in the States, to put your actual home address. And for creators that want to remain anonymous, one of which comes to mind heavily for me, who uses a stage name as their main name that everyone knows them by, for them to provide their legal name and their legal address would be quite literally doxing themselves.
So work through a company. That's easy. Work through a company. Form an LLC or a corporation.
They're Australian.
Okay, well, form an Australian company. It works really reasonably the same way there as it does here. You personally don't need to be the plaintiff. Okay, you don't need to necessarily.
The company can be.
The company can do it in your name. Now, it's technically you should move the ownership of the intellectual property into the company.
Right.
But look, one of the things about a DMCA takedown is if you're going to claim, well, if you're going to tell me to take down my stuff because it infringes your copyright, you're going to have to swear that you own that copyright, and that is all your stuff. Now, if you're doing an homage or a fan
fan art,
then you may not be able to swear that you own the copyright in your in your stuff.
Something like this. Hello. Right? It's a mini of Harley from Suicide Squad, but this was done for a friend of ours, Karen, for her birthday, which was last week, and Wexter, who's a 3D modeler, did this. Now, Marvel, DC, they don't seem to really care, right? They're like, look, just don't make it weird, and we're generally okay with it, and don't sell it, right? Don't sell a ton of it. And a lot of the creators skirt this, and they do it in a way that probably, so far, none of them have ever been challenged with it, but they say, you are supporting me via Patreon as an artist, and in exchange for that support, I release my models to you for no additional price.
Mm-hmm.
And that one's tough. A lot of the creators that do the fan art, maybe we'll see some of them pop in later on, but the ones that do some of this fan art, they never release it for sale otherwise. If you're not a part of their Patreon, you do not have access to it, period, end of story, because they recognize it is in direct copyright violation if they were to sell it. And to give it away would mean that they're not getting any support for the hours and hours and hours of work that they put into it. But when we look at original stuff, right, that has, and there's Creative Commons, just what kind of dictates this whole world of 3D printing. The 3D printing industry is weird because it's all based upon open source, which that might as well be a dirty word to attorneys because it's literally the exact opposite of what most for-profit businesses want to do, right? For-profit businesses, we want to maintain that intellectual property. We don't want to provide it out there. We don't want to do anything. We want to keep it so we can charge for it.
Yeah.
But this industry has found happiness, and like the 4 machines you see behind me are all 100% open source. I can source them for quite a bit less than I can buy them directly from the company, but I don't want to go through all that bullshit, so I'm just going to buy it from the company.
Right. Plus, if you buy it for the company, it might also come with a support contract.
That it does. It comes with a great support contract. It's freaking amazing.
Yeah.
But it is odd from a creator standpoint. It's why we don't release a lot of the work that we produce, even if it's just internal. Like, I am going to release the hurricane stuff. We will be releasing that. But a lot of the other stuff that I do for me personally, we don't release. We're working on a product called the Politician because it filters and produces hot air. It's a politician. Thank Jinx for that. That was Jinx. That was all Jinx for the name.
That's cute. No, that's
of course, he would come up with a name like that. But I'm not releasing that. We're going to keep it closed source, and we are not going to patent it because we can't trust that companies overseas that have a lackadaisical means of dealing with intellectual property won't just copy it and say, what are you going to do? Sue me? Good luck. So we're just
Well,
going to trade secret it.
as your comment implies, you can only sue on a U.S. patent in the U.S. or against people who
Correct.
make, use, or sell the patented invention in the U.S.
Yep.
If you want a patent globally, you got to go get a patent everywhere else, all the other countries. And that's not cheap, I can tell you, because a lot of times it involves language translation into, for example, Chinese and Japanese and German.
Even further, a lot of those require you to have a nexus in the country of origin, wherever you're trying to get it.
Generally not with patents, to be honest. With patents, you can generally
Really?
get a patent anywhere. Trademarks are a different story. If you're trying to do global trademark protection, you generally have to demonstrate that you're using the mark in the country. So anyway, yeah, it's tough. And it's tough to do global patenting. It's hundreds and hundreds of thousands of dollars if you want to get a patent, you know, in all the important countries, right?
Right. Yeah, and there are going to be some that don't matter, right?
Yeah,
It's
you
just
don't. I
not
don't
worth
think
your
you need a
time.
patent. I don't think you need to get a patent in, you know, Benin, at the moment, or Togo. But anyway, you may someday. Don't
Yep.
overlook these places because they're all entrepreneurs and they're all coming up. So
Build on
it's tough.
Sound is
Yeah,
saying
go.
what I struggle with really for buying models and etc. is I am never sure that the model I am paying for on said website actually goes to the designer. Sure, I will buy the cheapest I can find, but how am I sure the designers get what they're owed? That's always a
Yeah,
challenge.
so that's a matter of truth in advertising.
Yep.
What site did he say this person say he was on?
It's just so there are a few repositories out there that allow creators to sell. There's Cults 3D and My Mini Factory are going to be the two biggest ones. Cults and My Mini Factory recently put out statements regarding the profit share to their creators, and it's 85 and 90%, I believe, is what they pay out to their creators, which is pretty damn good considering credit card fees alone are going to eat up 5% of that.
Yeah, yeah.
You know, so I believe Colts is something like 90%, which I'm totally fine with. And me personally, if it is a creator that I buy from often, I mean, maybe this is because I can flex that influencer muscle. I'll just DM them somewhere and say, hey, I want to buy this model. Can I just send you money directly instead? Because I don't want you to eat any fees. And a lot of times they're totally cool with it. Right.
Oh, see, yeah. So that's one of those. There's just ethics flying all over the place here, right? Like, so when I was a boy back in college, we had. I was interested in photography. It was a little hobby of mine, and so when you wanted to buy a lens or a camera, you'd run down to the local camera shop and you'd get the feel of it and take a look at it and do all the things, and then you'd go home and you'd mail order it from West 57th in Manhattan because they had the best prices. And somebody, recognized this behavior and said, that's just not. I don't think that's terribly ethical. You're going into that store, you're using their time, their energy, their money. They're guiding you to a purchase decision and using their expertise. And you're not, the payback for that is to buy the product in the store, not go home and get the cheapest price. Well, so one method of doing business that is available to you as a human being is to go take advantage of free things that you can get from people and then go bargain hunt. Okay. And that's part of the conversation about, you go to the site, you saw the product on the site. It was because of the site that you even recognized this product or this designer. They kind of deserve their little, they get their feet wet, instead of going directly to in fact, if I'm writing the terms of service on that site, I'm going to make that a violation of the terms of service for you to go directly to the provider. Now, policing that is very difficult, obviously, but at least we've covered it in spirit. I'm not commenting in any way on your ethics, by the way. The way you see fit.
I know these creators, when I see them post pictures of it on Twitter, I'll be like, hey, what's the cost for that? How do I buy it?
Yeah, cool.
Yeah. It's not like I see it on My Mini Factory and I reach out to them directly,
Sure. And who doesn't like a deal, right? I mean, if you can get something wholesale, for goodness sakes, then it's even better. Now, as to the question, part of the modern internet is the rep economy, right?
Right.
Which is we have every buyer, every Uber driver has a star rating, every seller has a star rating.
Every business has a freaking star rating on
Every
Google.
business, I'm sure I do on multiple platforms that I don't pay enough attention to. Because it's always the negative people who are the loudest, right?
Oh,
I
for
mean,
sure.
we're dealing with a client just today, in fact, who had a disgruntled customer who went out and posted a negative review. And to put it in my client's words, you're entitled to your negative review. That's fine. If you honestly believe you were mistreated, you're entitled to your negative review. You're not entitled to 25 of them, however.
Well,
So
that's harassment. I mean,
that's what we've been engaged to yeah. So
yeah.
uh so look, I think you do the best you can, my friend, the person asking the question. I think you try to buy from reputable sources. You do some manner of investigation, go out and take a look, see if you can read their reviews. If you can always reach out to the designer personally as well and just say, hey, just want to make sure you're being treated fairly in this transaction if they're available. But it's tough. Okay, it's tough, and my hat is off to anybody who really dives in. We in my household have fallen victim to the, oh, let's buy something on the big commerce site that used to be a bookstore, and without checking the seller, the legitimacy of the seller, and getting something that just was markedly less than what we thought we were paying for, because we just didn't pay attention, because we just assumed, you go to Target, you see the thing on the shelf, you pick it up, and it's like, oh, this looks like a good thing, I think I'll buy it. And we don't have that ability now, so there's a lot of faith. But the great thing is that a lot of the sites, especially the big behemoth that used to be a bookstore, will do the returns generally, sight unseen. I mean, it's actually kind of amazing how easy it is to get your money back if you've been but that's slightly off the point. I first of all, I very much commend you, sir or ma'am, the person asking the question, for the inclination to want to make sure that people are being treated fairly and that kids are not being abused in the process of making things, or whatever the ethics is that you care about, and that puppies aren't being laden with eyeshadow and all these crazy things that goes on in the things.
Look, that puppy wanted to be fabulous, okay?
That puppy wanted to be fabulous. Who can blame him? Long story, won't go there. Anyway, the thing is, do what investigation you have and cross your fingers. I mean, hopefully people are being treated fairly and you're not dealing with big nasty sweatshop co.
Right. Before we get too far away from it, Russ, who's actually a Patreon member, thank you, Russ, for your support. Of course, links in that description if you do want to support us on Patreon for those that are watching. Russ said, can you clearly explain Creative Commons? Can I make and give to friends as a hobbyist? Like, can he 3D print something and give it to his friends? And how does that work with Creative Commons? Because Creative Commons is, from my understanding, it's just, there's no repercussions if you break it. It's just, hey, don't do that. You're not there's no ramifications.
Well, I think if there was a heinous enough breach of a Creative Commons license that if suing money was at stake, if there were millions of dollars at stake, someone would find a way to bring a breach of contract claim under a Creative Commons license. But the basic idea is, somebody puts something in the Creative Commons, they're effectively giving it away. They're effectively donating it to people who want to use it for the purposes that are enumerated in the Creative Commons license, right, which is generally free stuff. That you're not going to turn it around and necessarily make it into a profit-making venture. Does that happen? Of course it happens. People go to the Creative Commons. So think of a simple example. You're doing a PowerPoint presentation for a lecture. You're going to give a speech. You're going to, not a pitch deck necessarily, but okay, let's say it's a pitch deck. And you need a picture of an orange with a duck. I don't know. You run out to Creative Commons, you find that picture, you pull it under a Creative Commons license, you put it into your pitch deck, you go to the pitch, and it is an important slide in your pitch, and you get $1 million from your investor. Have you commercialized that photograph? I mean, I don't know, maybe. Is someone going to sue you for it? No, they're probably never going to know. unless you put your deck online. So it's hard to police. Look, can you pull stuff out of Creative Commons and use it to create stuff that you give to your friends? Of course you can. That's kind of the point.
If you're not selling it, you're not causing any damage. There
Yeah,
are
that's
no
right.
damages to be had because there is no exchange of money here.
Generally, right. You're living within the spirit of the Creative Commons license by repurposing and donating and giving. I think it's clear.
One that has always been weird to me, and this is as a content creator, right? I use designs all the time by creators. I always, shout them out and all that in the videos.
That's the big thing. No, the shout out is the big thing.
Right.
Man. I mean, literally, one of the things I found very early in my legal career was that people would come to me and say they took my stuff. They took my web design. They took my whole front page, and they didn't give me credit.
Yeah, they want the credit.
And that was the big thing for them. If they had dropped, if the theft had dropped, the thief had dropped a footnote and said, "Oh, this was shamelessly stolen from Joe Smith, who's an excellent designer, and I wish he worked for me." I mean, that would be all my guy needed to not be pissed off.
Yep. And a lot of times when they get to that point and they've asked and they don't give it, now they want money.
Yeah, turns out. Yeah, I mean, that's what all of this comes down to at some point is who pays what to whom.
It's like, here's a good example. This is a bust of the late Sanjay Mortimer. In fact, I interviewed Sanjay about a month before his death, which is still, it was shocking to the industry. He was 31 years old, I believe, 31 years old. And a great guy. This is made by Sid Naik, who's a phenomenal 3D modeler. I mean, this is spitting image of Sanjay. It looks beautiful. Wow. And it has, or I believe it did when I downloaded it and used it, a non-commercial license, right? Now, I've talked with Sanjay's mom and, the E3D team, and I even talked with Sid about this. I said, Sid, is it okay if I make a time lapse and we put it on our YouTube channel? Because ultimately, I might make 10 cents from that with how good YouTube Shorts pay out. So technically, this is a commercial use. He's like, I don't see it as a commercial use, dude. This only benefits me at the end of the day. People see this, they're gonna go download this model. Please, by all means. He says, as long as you put it on there that I made it, we're cool. And I said, always, 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 always.
So one of the great things you just said was, I don't see it as, because really that's the essence of the solution to any legal problem.
Right.
It's who's gonna see it as right and who's going to see it as wrong. And is that person you? Is that person me?
Mm-hmm.
Is that person the judge?
Mm-hmm.
Is that person the jury? Okay. And who can convince those people to see it that way is really what all of this comes down to. If the designer of that bust didn't see it that way and saw it as a commercial use, well, now you might have a plaintiff on your hands if you went forward.
It's true.
So that's really the whole essence. I must say, one of the interesting dynamics at work there, however, is the whole, like I said, I wouldn't sue you if you had just given me credit. The inverse of that is it's tempting to think, well, I can take this intellectual property and infringe it, because everything I'm doing is good for the holder, the owner of the intellectual property. Like I'm promoting, Disney or whatever by infringing, by copying Mickey Mouse. Like more people are coming to the park because of my efforts. Not a factor. Okay, I mean, it's not a legal factor. It's not an element of anyone's defense.
Right.
That I'm actually making more money for you, so you shouldn't sue me for infringement. That's not a compelling argument most of the time.
That's fair.
Just FYI.
Build on Sound is asking, so here's a question. If you make a model replica of something that's already known IP, say Doom, something from the Doom video game series, how does this not breach IP law? It's a bit vague for me on that part.
So this comes down to a sliver of, well, a large chunk of intellectual property law called copyright.
Yep.
That's how you own characters and audiovisual works and literary works and sculptures and busts, and most of the stuff that comes out of a 3D printer, if it's ownable, is going to be protected by copyright. It's going to be owned by, its ownership will be dictated and determined by copyright law.
Right.
And so if you copy something that I own, and you make a literal copy of it without my permission, then that's probably a copyright infringement. If you have had access to something that I own, and then you, without looking at it, you go and you create something that is substantially similar to it, that is also a copyright infringement. So effectively, looking at my stuff and making your stuff that's the same stuff as my stuff is the classic definition of a copyright infringement. Now, when is that not a copyright infringement? And that is when it's a fair use. What is a fair use? A fair use is an exception to a claim of copyright infringement, where the copyist basically says, I know I copied this thing, but that's okay. It's a fair use. It's not copyright infringement. I'm entitled to copy this thing for various reasons, okay? One of those reasons is that you didn't copy enough, okay? So if the people who own Doom have a copyright in the entire Doom world and all of the characters and all of the literary works and all of the audiovisual works and all of the music and all of the things that go along with the Doom experience, then the question is, you know, how much of that can you copy with still being a fair use without infringing the entire copyright on Doom? Unfortunately, the question is a little skewed because each individual character is going to be the subject of separate copyrights as well. Each individual story, each individual episode could potentially be its own copyrighted work.
It gets deep really fast.
It does get deep, and it gets subtle, and it gets difficult. Because here's the thing. The standard for how much you can take from existing copyrighted work and still call it a fair use is called the heart. It's the heart standard. Are you taking the heart of the work? Okay, so what is the heart of Doom? Who knows? I mean, who could possibly say what that would be? But unfortunately, if the character, which is going to pretty much assume, you have to assume that the character itself is going to be subject to its own separate copyright. Think of Mickey Mouse versus Minnie Mouse versus Donald Duck. Each of these characters is a copyrighted thing, a copyrighted character. And copying Donald Duck, the fair use analysis will not be thrown up against all of Disney and all of Disney's content and all their movies. It'll be thrown up against Donald Duck, right?
Yeah.
Okay.
Yeah.
So if you copy a Doom character, unfortunately, there's really very few ways to say that you haven't taken the heart of that character, because you've probably taken the whole character and copied it. There are other exceptions that can be applied in a fair use analysis. For example, it is always permissible to copy for the purposes of comment and criticism.
Right.
So, for example, if you're writing an article about Doom and you want to use a picture of a scene or a picture of a character or something like that, or maybe, you know, there could be situations where a 3D rendering of a Doom character was done for comment and criticism and maybe even satire or parody.
That's a lot of work for satire and parody, but
fully protected. Okay?
I don't put it past this industry to do a shitload of work for a joke, okay?
The Supreme Court has said, however, that you have a constitutional right to make fun of things.
Damn straight they do.
Copy them in order to do so. So if you're copying that Doom character in order to make fun of it or make fun of Doom, then you're fine. Note, however, that you have to be making fun of the character or the foundational copyrighted work, or potentially the owners of the copyrighted work, right? So you can copy The Simpsons to make fun of Fox Broadcasting or The Simpsons, but you probably can't copy the systems to make fun of Fox News, because those are two separate companies, and Fox News doesn't own The Simpsons. So now there's one other area, there's numerous actually, but there's one other area that's worth mentioning here, which is if you are copying for nonprofit or educational purposes, solely for nonprofit or educational purposes, you may be in fair use territory.
Yeah.
Okay. But it's not a slam dunk. Okay. If your employees come to you and they say, we copied some stuff and we put it in our product and we shipped it, but it's okay because it's a fair use, you should fire those employees, because the fair use analysis is complicated It's non-algorithmic. There are four factors that need to be weighed by the judge to determine whether or not you've got a fair use defense to a claim of copyright infringement. It is very difficult to predict whether your particular copy will be found to be a fair use. I can tell you this, one of the seminal cases in fair use jurisprudence is the case of the Washington Post had done a book review of President Ford's biography. And in the book review in the Washington Post, I think it was the Post, I hope I'm not getting that wrong. They actually quoted from the book, from the book, they quoted the two paragraphs in which President Ford explained his reasoning for pardoning President Nixon. As you may recall, President Nixon was being impeached and he resigned, and President Ford pardoned him. And the Washington District Court in Washington, D.C. ruled that the copying of those two paragraphs from the entire book was in fact the heart of the work, because the only thing anybody cared about with respect to President Ford's biography
was the reasoning
for pardoning President Nixon, because he wasn't one of our most vivacious and exciting presidents, you know?
No.
So anyway, you got to be careful. I can't predict. If you come to me and you say, I'm copying this Doom character and I'm giving it away to poor children so they can eat, I'm going to say good on you, but I cannot guarantee that you won't get sued for copyright infringement. I just can't. And that's really important to leaven into this discussion. You and I can talk all day about what we see. That was what you said. I don't see that as an infringement. That's great. I don't see that as an infringement
It's what
either.
the law sees.
Let's proceed. But who's going to sue whom and who's going to win is what it all comes down to, right? And if there's gold in them nar hills, right? If there's enough money at stake, lawsuits begin to happen at that point. Until there's enough money at stake, demand letters happen, right? Cease and desist.
Yeah, C&Ds.
Yeah. Now, I will say, however, that even though your activity may be low profit or no profit, if you're not a 501c3, you're not doing nonprofit work. Okay,
correct.
I don't care if you're giving stuff away.
I don't care if you're losing money.
You're right. No, yeah, your commercial activity is presumed to be for profit unless you have some kind of tax-free designation from the government.
I joke that, I've run a very successful nonprofit for the past 2 years, right? But it's not a 501c3. It's a joke. And that the last 2 years kind of sucked.
That's really important. No, that's really important. In the fair use analysis, not-for-profit uses of copies can sometimes be a fair use. But again, just because you're not making money does not make your use a nonprofit use by any means.
Mm-hmm.
So all commerce is presumed to be for profit,
right?
Whether you're profiting or not. In reality.
My dad's actually here. He's asking, is it the reasonable person standard, or is there some higher and or lower standard that is used when it comes to copyright? Because it really can get kind of
Dad. Jeez.
Well, he's now in an art college. I feel like that's
Mr.
a pretty good question for him.
Down there at Ringling College of Art and Design. Ringling College of Art and Design, one of my favorite places in the world. Tell Larry Thompson that Brent Britton said hi, please.
It's also Dr. Posner. He did get his PhD.
I beg your pardon, Dr. Posner. I should have guessed. I beg your pardon. The reasonable person standard is one of these things that is injected in various veins throughout all of the law. Yeah. Especially the law of torts and things where I can sue you for intentional infliction of emotional distress, right? Would the average person say that your behavior is outrageous? Would the reasonable person, be outraged or whatnot? So I can't claim, if you read through various copyright cases, I'm not going to claim that you won't see reasonableness imposed as part of the discussion. But no, to my best of my recollection, there's nothing about a claim of copyright infringement that necessarily relies on any reasonable person standard. Copyright infringement is, with the exception of fair use, which I hope I've demonstrated is a big, complex, fact-specific area that just can't really be easily predicted as to how it's going to come out. Except the parody satire stuff. I'm very confident that if you're copying for satire, you're going to win. You're not going to see a lot of reasonable person stuff. Generally, the rule is if you make a copy, you're infringing.
Mhm.
Okay. If you take somebody else's stuff, there's not a lot of latitude, to get away with that. I mean, again, there is this massive fair use bundle of ideas out here, and a lot of people rely on that. And one of the problems we have with some websites, some places, for example, you may recall there was a VR that was popular over 10 years ago now called Second Life.
Oh yeah. Yep.
And one of the things about a VR is that you can make the law and you can encode it in your software. And if your software says you can't copy, then you can't copy. And so there's no copyright infringement if you literally can't physically make the copy or virtually make the copy.
Right.
But but see, the problem there is you do have a fair use right. You do have the right to copy some things under the fair use analysis. And so if I impose just a no copying rule in my world, am I commensurate with the law? Am I harmonizing with the law? Am I preventing people their constitutional right to copy a fair use? Don't know. I think the issue, though, based on, and I appreciate the question, that much of the law is based on a reasonableness or reasonable person standard. If we write a contract, we almost never have to use the word reasonable because reasonableness will be implied in the words of the contract, right? But generally with copyright, I'm sure there's an exception that I'm misremembering, and all my lawyer friends are going to be like, "You totally forgot about the Smith versus Jones case. What's wrong with you?" But no, generally no. You infringe, you copy, you infringe, and there are a bunch of crazy counterintuitive rules that the reasonable person would not appreciate. For example, if you hire me to build you a table, and we don't sign a contract, right? And I'm not your employer or anything. We're just independent handshaking. Right. You say, build me a table and I'll give you $100. And I build you the table and I deliver it and you give me the $100. Well, I own the $100 and you own the table and everybody agrees that that's true. And the law is not going to mess with that. But if you tell me to paint you a painting or write you a book or create some 3D sculpture, for example, and we don't have a contract and we don't have any pre-existing relationship and I'm just independent handshakers, and I deliver that copyrightable work to you and we haven't signed a contract, okay, and you pay me my $100, well, I own the $100 and I still own the copyright into the thing that I delivered to you, and I can make more copies of it and I can sell it to other people and you can't.
Yeah, you got to make sure
you only have an implied license to use. And reasonable people would argue with that. They would say, hey, I bought and paid for this thing. What do you mean I don't own it? Sorry, copyright only transfers in writing. So if I sell you something, you have a limited implied license to use it for whatever purposes we kind of anticipated you would use it for, as perhaps evidenced by our email history or something like that.
Right.
But generally, I do too, and I can keep using it because it's mine and it's not yours, even though you paid for it. Thank you. So yeah, there's a lot of not reasonable person stuff in intellectual property, and the ownership analysis can be very counterintuitive and unexpected.
When we look at parodies, something that I don't know why this went through the industry, but it did, putting Dwayne "The Rock" Johnson's bust on everything, including a lobster. So it was Dwayne "The Rock" Lobster. That is considered a parody, as far as I'm concerned. But I'll be damned if it was not a very, very good sculpt of his face.
Well, here's the thing about that. We're no longer in copyright town anymore. Now we've moved over to a related neighborhood with slightly different rules called rights of persona.
Okay.
And there's no parody exception to rights of persona.
Oh, shit.
If you copy, there's the great case in rights of, and as you might imagine, most of these cases come out of LA, come out of Hollywood.
Of course they do.
Because you and I don't have a very strong right of persona.
Excuse me, I have 6,600 subscribers on YouTube. Clearly,
I beg your pardon, sir. Please forgive me. Clearly a major celebrity.
Yes. I've been recognized in public twice.
I have 5,000 followers on LinkedIn. So there, anyway, I don't have a very strong right of persona, but if you copy my face and put it on things, I can sue you for other things. I can sue you for invasion of privacy or something like that. But if you're popular and you have a persona, you can protect it. One of the seminal cases here was, I forget the defendant. I'm going to say it was Samsung. Years ago, late 80s, did a commercial where they were doing a parody of a future version of Wheel of Fortune. And they had a very future version of Wheel of Fortune. And they had this robot with a blonde wig who would sort of dance out into the scene and turn the letters and then come back. And Vanna White sued them for theft of persona and won, even though there was no Vanna White mentioned. There was nothing that looked like Vanna White other than she is known as the bouncy blonde leather turner on Wheel of Fortune. And so you can't parody in rights of persona. If you call to the mind of the reasonable person, perhaps Dr. Posner, if you're still out there, that if you call that celebrity or that persona to mind, then yeah, you might have to pay for their use of it, because that's how they feed their kids, is with their face.
Well, yeah,
okay?
that's how they pay their bills. Yeah,
public appearances and their image and their likeness. So there's no parody. Generally, there's no parody exception. There is a news and reporting exception. Okay, I mean, if you're reporting the news and Dwayne "The Rock" Johnson, walking down Hollywood Boulevard in his underwear or something, you can use that imagery without because
that's fact, right? That's
right. Yeah,
that's fact.
Yeah.
If he used AI to simulate that and said, "Well, this is what it looked like if he would do it," that's defamation.
This is our artist's rendering of what it must have looked like. Yeah. So you got to be careful. You got to be careful there. I mean, look, nobody owns facts. It is true. But if it is a fact that you are nude sunbathing in your backyard and I fly a drone over your backyard and take pictures of you and publish them in my magazine, what's a magazine? Publish them on my website. That may be an invasion of privacy. Okay. So facts may be this thing that we have to be very careful about how we define.
Right. Okay. But then we have the court of law, but it's 2022. We got the court of public opinion. And sure, The Rock could have had all of those removed, but boy, howdy, that would have pissed off some people. Now, technically, he's in the right, but there becomes a point where the court of public opinion is stronger than the court of law. That's a fun one to deal with too when you're a celebrity. From what I understood, he was generally okay with it. In fact, he did a lot of TikToks where he was like replying to these and being a jokester with them. So clearly he enjoyed it. But there's this whole thing of, wait a minute,
so
are you supposed to go after them?
I think the privileged get a lot of mileage out of being a good sport. Okay, if I'm managing, if I'm his lawyer, we would have had a discussion, right, about, look, how does this play? Are you looking like a monster if you go after the kid with the thing? Or do you want to play with this? Do you want to start getting in some tweet discussions like, that doesn't look a thing like me, what's wrong with you people? Which can also backfire. Okay, I mean, sometimes the nicest efforts can backfire and turn into, oh, he's so conceited, or whatever the charge might be, or who do you think you are, Dwayne? Or whenever anybody is in a position to be deciding whether they should sue, whether they should call out the lawyers to start sending the cease and desist letters, there's got to be a PR function to that. But I gotta tell you, one of the things that's, you really ought to know this. People have come to me many times over the past 25, 30 years and have said, if we sue them, they're going to cave because they don't want a lawsuit right now, right? If we threaten to sue them, they're going to play ball because they're looking for funding, or they're looking to sell their company, or they're trying to behave because they've got some other problem over here, or they're very busy and they can't afford lawyers. And it's never been a factor, okay? It's never true, because everyone thinks they're right. Everyone thinks they're right all the time. Even when they know they're wrong, nobody's scared of a lawsuit, okay? Nobody wants to pay lawyers, and it's all very expensive.
No, yeah,
and it
the
puts the
lawyers
fear
aren't
of God,
cheap. No offense.
and just the threat of a lawsuit can put the fear of God into seasoned executives, okay? No doubt about it. But if there's a lawsuit that needs to happen, they're not going to cave just because you send them a nastygram, okay?
Right.
You know, and I guess another flavor of this issue, and this dovetails into the Rock, you know, sort of being a good sport, is you often hear about the kind and gentle cease and desist letter, right? There was a kid years ago, 10, 15 years ago now, who had been copying the Jack Daniels label. And maybe putting it on t-shirts or maybe putting it on something else. I don't remember with any detail. And the lawyer who wrote to this kid was just perfect, right? Hey there, bud. I know we really appreciate your interest in our artwork, but turns out we have to ask you to stop because you're infringing our copyrights. And I know that sucks, but I'll tell you what, maybe we could get into a licensing discussion where you give us a nickel for each one or something like that. And so people posted it on the internet and was like, look, not all lawyers have dark souls and tarred hearts. And
yeah, that was a lawyer who worked directly with a PR firm, or a lawyer that might have come out of CoreX that actually understands how to do things a little bit more eloquently when it's required.
Here's the problem, though. Here's the problem. So literally inspired by cases like that, because there have been a few. I did this very thing. I started imposing on my team that when we send a demand letter now, we're just going to do more hand-holding than anything else. And we're going to say, hey, we sure you didn't mean this, but turns out what you're doing is a violation of our client's rights. And so we're going to need you to stop. And gosh, we'd really hate to have to file a lawsuit here. So maybe you could write us a check. Maybe you'd be kind enough to drop us, 25 grand, and we'll be looking for that. Thanks. And it never worked. Never.
It'd be a real shame if we went to court.
Well, it'd be a shame if something happened to you, right? Yeah, no, but we tried. We wrote the nice demand letter, and we got this in response. And for those of you not looking at the video, I'm holding up my middle finger. Let the record reflect that the witness raised his middle finger, and not in that old 70s way either, but in that cool modern way.
Yeah, with the I don't know, it hurts my hand to do it that way.
Anyway, my point is, if somebody has harmed you and you're hiring counsel to pursue remedies, it's going to be ugly. The gloves are off, and the demand letter is going to sound like, you have done everything in the world that's possibly wrong, and we're going to kill you and your children and their children, and we're going to make God's own fury fall down on your head unless you pay attention to us. And that's just the game. That's how litigation works, which is why I personally am not very good at it. To be candid, I don't understand. I do deals, right? I negotiate with the other side to do a deal that, when it's done, is going to help both sides. Because a bargain is a truly miraculous thing. A bargain is a deal where I give you something and you give me something back, and we both feel like we're better off.
That's the win.
Amazing, right? It's a miracle that we humans can actually engage in bargaining, but we do it all the time. And when it works, it's fantastic. And when my job is done, we pull out champagne bottles and we have ourselves a little congratulatory party. And when litigators' jobs are done, unfortunately, it's maybe somebody won, but God, the years of crap that you have to go through to deal with dispute resolution is daunting. I have been involved in many cases, both personally and professionally, over the years, that one would think would just be open and shut. I mean, come on, we have all the facts here, but they're not, because of zealous advocacy, because it is every lawyer's job to pursue the truth of their client's case as zealously and as energetically as possible. And that is what we have decided in the United States is most likely to lead to truth, which is just pounding on each other and hiding the ball and scorching the earth and doing your best you can to win. So that's how we do it here, which means the nice hand-holding, gentle cease and desist letter, unless it's going to a kid. All right. If I'm sending a cease and desist to a 12-year-old, I'm probably going to be pretty keen about it.
I remember getting my most recent one. It was from a very prominent artist, Dow Bloomberg, because we were working with the Horse Soldier Bourbon Company.
Oh, yeah, I know those guys.
Yeah, they owe me like $5,000. Yeah, we're gonna get into it right now. It'll be fun. So, they're depicted. The guys that made the Horse Soldier Bourbon Company utilize an image of the sculpture of Dow Bloomberg sculpture, which is at a 125% scale at the 9/11 memorial site. Well, they reached out to us and contracted us to produce miniature versions of it. I did my research and I found there was a 125%, there's a 100%, and then there are 8-inch versions. They wanted a 12-inch. Wait a minute. If they're a different size, that means somebody has the data somewhere.
I mean,
I don't want to charge them for it because I'd have to fly up to New York and scan it. It's a pain in the ass. So
8-inch, 12-inch, they're both doing fine, if you ask me.
Hey, yeah, I wouldn't complain for either. I end up talking.
Let me interrupt you, Grant, just because there's no way on God's green earth I'm going to make any comment whatsoever.
There isn't.
To the facts that you're reciting to me right now. I'm happy to listen, by all means.
No, it's just a fun one. Lo and behold, I end up speaking directly to Dow. He says they don't have the rights to do this. They don't have reproduction rights. He said they have the rights to put it on their bottle, but they don't have the rights to actually make the models. He said, unfortunately, I got to send you a cease and desist. And it was one of the nicest cease and desists that I've ever gotten. It's very formal on the front. There's page 2, which is handwritten, hand-signed, that says, I understand that you're losing a lot of money on this. I'm sorry. This is nothing personal. It's business. And that it helped make that $5,000 a little bit less hurtful. Because it wasn't his fault. It wasn't my fault. It was their fault. And they make good bourbon. I'm not going to deny that. It's not bad bourbon. But yeah, that's my story of how I met a very famous artist for all the wrong reasons. And there are right and wrong ways to do it. It's fun.
Yeah. Good. I'm glad you're having fun with
it. Ultimately, having a lawyer then would have been good. Because there could have been some research done. Their lawyer should have done research. I think there were a lot of things that could have been done before it came under my watch. But I think ultimately,
I think that is a truth. That is a truth that I wasn't sure was true. Even though we said it for many years, we said hire us now to prevent problems, and you'll spend less money than if you hire us later to fix problems. Because, and the reason I doubted the veracity of that statement is because we're pretty good at fixing problems too. Even after you break stuff, we can come along and fix it. But in general, on average, I think under the Poisson distribution of the normal curve, in the balance, you will spend less money if you hire counsel at the beginning than if you wait until something goes wrong. But it's a bit of a Pascal's wager, isn't it? Because something might not go wrong.
Right.
And if you don't lawyer your deal and everything goes fine, then great. You've never had to spend a dime on a lawyer. So you have this little 2x2 matrix where, unfortunately, the downside of not hiring a lawyer early and having to hire them later is, as with Pascal's wager, so horrible that it's always better, I think, to just have me take a look at it, for God's sakes. It's like, hey, what do you see here? Any red flags? And what am I going to charge you? $500? I don't know. I'm going to work up for now.
It is cheaper to do that than it is to say, I got screwed and I need your help getting my money.
Precisely. That's exactly my point. Or unfortunately, I got screwed and I'm being told I have to write a $5,000 check. Very nicely, mind you, with a great deal of hand-holding. I'm being told I have to write a $5,000 check. Do I have to? And so, right? Yeah.
It is definitely complicated. And DMCA is not, it's not 100%, right? If they don't respond or they don't do anything, you're effectively forced to get an attorney. And a lot of these smaller creators can't functionally afford it, right? If I needed to hire CoreX Legal to go after someone for stealing, I don't know, some intellectual property. Maybe they somehow got a copy of The Politician, reverse engineered it, and started going after it. That would be so monumentally expensive up front. Now, of course, you sue with damages plus legal expenses, correct?
Well, it depends, right? I
Okay.
mean, if you come to me and say, I've got a copyright infringement case, I'm going to ask you how much it's worth, right? I mean, what are your, how much profits are you losing? How much profits are they making? What is the intrinsic value of the work? We're going to figure out a damages,
Right.
sort of case, like what is this case worth? If the case is worth enough, I can be very creative about fees, and I can potentially, if I think it's a strong case and I think there's millions of dollars, literally millions of dollars at stake, I might be able to take some of that on contingency, right? So I get paid when we win. Not all of it, right? Unfortunately, but some of it. There are firms that will do more contingency fee work, but generally not in intellectual property cases. It's tough to find a firm that will do it because it's just outcomes are difficult to predict. It's not personal injury. Personal injury is kind of easy. There's a car and there's someone bloody in the street.
It's also the law.
So right, yeah, and so personal injury are easy to take on contingency because the strength of the case is kind of obvious all along. But if you come to me with a case with any, especially intellectual property litigation, which is all federal for the most part, except for a few trade secret, but you can sue that in federal court too now. I'm going to say I need a $20,000 retainer, and it's probably going to be $10,000 a month on top of that for the foreseeable future, on average. Some months might be $2,000, some months might be $80,000, but litigation is crushingly expensive.
Yes, it is.
And
it is incredibly expensive.
Yeah. So yeah, if you're going to sue somebody, it's got to be worth it. Which unfortunately means there's this whole level of commerce, like right here, right at eye level, below which people can get away with stuff because they know you're unlikely to pursue them.
It costs you too much money to do it. And unless they want to make a point, right? Disney is known for doing this. So is Nintendo. They'll sue to make a point.
And sometimes they have to, because with intellectual property, it's similar to real estate, which is like, if I let you walk across my lawn without stopping you for 10 years, I can't stop you. Turns out after a while, you've earned the right because I haven't stopped. Same is true with trademark, patent, copyright infringement. There at least can be argued that if you sit on your rights and you don't pursue them, then the world is assuming it's okay, right? Well, that guy gets to walk across the lawn every day. I might as well walk across the lawn too. Why aren't you suing me? Right? So sometimes the intellectual property holder must be the bad guy. Somebody had to decide with Dwayne "The Rock" Johnson that Dwayne "The Rock" Lobster was not going to cost him too much in terms of his future ability to control his likeness. Because if it was, he's got a very valuable likeness. He would have to have put a stop to it. He would have to, because otherwise he's going to forestall his future ability to profit from his own face. So sometimes you will get sued for trademark infringement or what have you, copyright infringement, even though you're not making any money, just because the owner of that IP needs to actively police and protect it in order to maintain their ownership. Yeah.
Boy, it gets real spicy when you really dig into it.
It does, but when you really think about it, it's rational, okay? Because what we've decided in this country, and we could have wired up this country very different. We could have wired it up to say, if you create something, it belongs to all of us, and we can all make more profit, or we can all make the world a better place by sharing our creations than by owning them exclusively. But what we decided in this country is that we'll get more value, we'll get more good stuff, we'll get more invention, we'll get more literature, we'll get more copyrights, we'll get more designs, if we let the people who create those things own them exclusively for some period of time. And the exclusive ownership comes with the right to prevent other people from using those things during the period of exclusive ownership. And generally, I think that's an accurate thing. I mean, I think the founding fathers in 1787, when they ratified the Constitution, got it right. Look at this, look at what they hath wrought in this country with respect to innovation. I mean, Americans have invented more stuff than most of the rest of the world combined in the past 200 years. And there's no end in sight. Just look at Apple, for God's sakes. And, I mean, it's just one example of how much,
It's true.
whatever you may think of Apple or their products, you can't deny that they have been hyper, mega innovative over the past 20 or 30 years. And part of that is due to the fact that they got to own exclusively the stuff that they invented, and they didn't have to share it, and they didn't have to give it away, and they got to make a shit ton of money. Pardon my French. They got to make a whole ton of money. And
you're able to cuss on here. I don't care.
Oh, all right. Well, fuck that though.
Yeah.
Anyway, so look, it does get spicy, and it does get expensive, and it does get tedious. There are definitely times when it's like, can't we just all work it out, for God's sakes? Why all these lawsuits and stuff?
Because the U.S. is also the most litigious society out there too, right? We might have a lot of innovation, but we got a lot of lawyers, and we sue people. I mean, literally, people say, "I'm just going to sue you."
Yeah.
You don't even know how to do that.
But again, if we're programming the country, if you're wiring up a new society, you have to think through the options for dealing with stuff like this. And our court system is there to resolve disputes, or as you put it, as I see it versus how you see it. Because if not for that, then we're pulling out swords and we're lobbing each other's heads off. Or
I'm all for that. That's nice and simple, right?
We should just go back to feudal rights of
Hey, at some point, a fight to the death is going to solve this problem a lot faster. Okay.
Definitely is. That's going to be much more conclusive.
Duff, who's up in Canada, says, "I'm just jealous how you Americans can get awarded costs."
Oh, yeah. And that's not always available, right? Sometimes it is. We write it into contracts most of the time to say that if the parties to this contract enter into a dispute, that the prevailing party will be entitled to collection of their legal fees and costs. And yeah, that's a thing. It's prohibited in some causes of action, and it is expressly permitted in others. In trademark infringement cases, there have to be exceptions. I mean, one of the big downsides of litigation, and the fact that you can be sued for anything, anytime, anywhere, is that you have to respond. If you don't respond, you lose by default. So you have to show up, you have to file an answer, you have to participate in the process, you have to file, even if it's baseless, you still have to file a motion to dismiss or some similar pleading which tries to get you out of the case. My point is, I could sue you tomorrow, Grant, for reasons that I just made up out of whole cloth because I'm a psychopath. And you would have to go spend a few $1,000s on a lawyer to get out of that case.
Yep.
And you might not be able to get your fees from me. Okay, I mean, you'd only be able to get your fees from me if I was being, to quote Dr. Posner, if I was being completely unreasonable, if I had no factual or reasonable basis for my ability to bring that lawsuit, so you're just spending money and you're not collecting it back in many cases. So it's tough.
I think it's a valid question we have from one of our commenters, Zombie Hedgehog, whose name is Austin. He says,
"So, and by the way, hello to the Great White North. We're always happy to have our Canadian friends."
I think so far we have 3 different continents on here. So
fantastic. What are you people are up late? What are you doing here?
Oh, they're always up late.
Early.
It's like 9 o'clock for the UK right now. They're fine.
Right, it's 9 o'clock in the UK, but it's basically mid morning in Bali right now, so, or like 4 a.m. So
we're not that far yet.
Okay.
But Zombie Hedgehog Austin is asking, so at what stage do you create a contract with a lawyer? Is it when you don't currently need one? Like when is it best to start looking into getting a lawyer?
If you're in business, if you're engaging in commerce, you really ought to bounce what you're doing off a friendly lawyer. Okay. Most lawyers will give you a 20-minute consultation off the clock. I'll give you a 20-minute consultation off the clock. But my general rule is, if you're in business, you need to have a company. Okay. You generally shouldn't be conducting business as an individual. And the reason is that if you get sued for doing something wrong, then your personal assets are going to be at risk. Your personal bank accounts and home and garden and artesian well.
Yep.
So you form a company and you do your business within a company so that if you do something wrong that gets you sued, they sue the company and they can only get at the company's assets, not your personal assets. So you don't necessarily need counsel for that, but it's a good idea to have a lawyer look at your formation documents. If you're just a solo, chances are you don't need a lot in this regard, but definitely having a company formed is a really good first step to ensuring your personal assets against attachment.
But also make sure it's not a sole proprietorship, because then there is no protection still.
That's not a company. No, we're talking LLC or corporation.
Absolutely.
And LLCs, single member LLCs are frowned upon. I much prefer a single member corporation if there's only one owner, for reasons I won't get into. But so I think the idea is the expectation, the need for you to reach out to legal counsel is going to be more or less proportional to the amount of money flowing through your life. Okay, if you've got a business that's just it's making $200-300 a week, or whatever, and it's sort of keeping you in mac and cheese and you're happy, you don't need counsel for a lot of that. And look, so here's the problem, right? You suddenly decide I've got this great brand name, let's call it, I don't know, Xcore, and I want to get a trademark on it. So you go to LegalZoom and they walk you through, they handhold you through filing a trademark application. 20-30% of the time you're going to get it wrong. You're going to make a mistake. You're not going to understand an instruction correctly. I'm not casting any aspersions on LegalZoom. I think they do a wonderful job, but I get a lot of refugees from the do-it-yourself world who busted it in the process. So you just have to balance all this with what you're really capable of focusing on. I mean, I can watch a YouTube video and I can fix the wiring in my house, but I'll probably take 4 trips to Home Depot, and I'll have to go buy a saw at some point. Or what? My point is, I could get a guy here or a gal to fix my wiring for $500, and they'll do it right, and it'll be insured, and all the other things. If they don't do it right, they'll come back and fix it. So why not hire the electrician to work on your wiring? And the same is with lawyers. You can DIY it for a long time, and if there's not a lot of money at stake, then why bother? Why pay money to get someone? But when you need expert advice, when you need someone who knows how to file a patent application, or knows how to file a trademark, or knows how to do a filing with the Secretary of State or something like that, we just snap those things out. We just make it rain with stuff like that. We're good at it, and we're not terribly expensive. Well, we're not the low cost provider, but there's a lawyer out there somewhere who can do the work that you need done. Whether it's CoreX Legal or somebody else. So I very much appreciate the question, because I'm trying to think of an analog in life, but I guess when do you need a suppose you start running and you decide you enjoy running and you're having a good time and you do a 5K every morning before sunrise. When do you need a trainer? Well, when your knees hurt, or when you decide you want to start running competitively, or you want to train for a marathon. Then when things get serious, then it's time to get experts involved who know the ropes and have done it a million times and can do it for you. So that's sorry, it's a mushy answer to your question, but
it's kind of a mushy question, right?
But the truth is, I've started many companies myself, and I have counsel on board from the beginning. Okay. Whether it's me or somebody else, I mean, I don't think you're taking your entrepreneurial endeavors seriously if you don't have a good lawyer and a good CPA nearby. And it's because your success is going to depend in large measure on the expertise you surround yourself with.
I agree with that.
Just a fact.
JL Stern is asking, if a patent has been filed and waiting for review, do you hold off launching the product, or do you let it ride as patent pending? Now, my opinion is you go as patent pending, because, buddy, it's going to take like 2 years to get that thing out there while you're waiting, so you might as well get it on the market, because you're still protected. It's the first to file, but I'm also not an attorney.
Well, I can answer. You're right. I think you're right. I think patents are nice to have, and I think you file them when you're entitled to file them, and patent counsel will tell you whether you've got something that's patentable.
Good Lord, they're expensive.
And then you sit and wait, and if it's really important for you to get your patent, MO is typically, let's file provisional patents on everything you can think of. Okay.
That. Always that.
Provisional patents are short-term filings that you file at the Patent and Trademark Office in the United States. They last for 1 year. They're not enforceable. They're not infringible. You can't sue anybody for infringing your provisional patent. It's just a disclosure. It just describes your invention. And in not necessarily particularly rigorous language, although it does have to teach, which is to say, an engineer of reasonable skill in the art, a particular art of your invention, whether it's electrical engineering or mechanical or what have you, should be able to build the invention by reading your provisional patents. Okay. And you can file it yourself. You can go to LegalZoom and you can file a provisional patent. If you come to me, we're going to charge you $4 or $5 to draft a provisional patent. It lasts for 1 year. It allows you to say patent pending. It allows you to tell investors, we're filing patents, we're filing provisional patents. It does not allow you to say false things like we own the patents in this space. Or things that'll get you sued by investors and they'll be called fraudulent. But yes, you file all the patents you're entitled to. If within that year that the provisional patent is sitting there, and make no mistake, it just sits there. It doesn't get read. It doesn't get examined. I'm shocked if it even gets opened by somebody at the Patent and Trademark
Only
Office.
if there's litigation, right?
Well, no, because eventually you convert it. You can convert the provisional patent to a non-provisional patent application, and the later, if you do that within the first year, the later filed non-provisional patent application will enjoy the priority date on the earlier filed provisional patent. So that's good because, as you point out, first to file matters. So getting your provisional patents in early is a relatively inexpensive way to get those priority dates early. You never wait to release. If I can't think of a circumstance where it would make sense to wait to sell a product for the patent to issue. There's just absolutely no reason for that.
You're sitting on a lot of money for no reason.
Almost divorced from the commercial pursuit. Now, if you've done a patent search and you know that a competitor is out there with a patent or a pending patent that's going to issue anytime soon, and you know for a fact that your invention reads on that patent, you may want to rethink your deployment of that product, or you may want to invent around that existing patent before you deploy. But most people don't do that either. It's very, I mean, just witness all the patent prosecution, patent litigation that goes on in the world. So I say no, you never hold up commerce and profit waiting for a patent to issue by any means. You pursue those patents as vigorously as you can, and then when you get them, you decide whether or not you want to sue anybody. But for the most part, that's divorced from how well your product's doing in the marketplace.
And boy, howdy, patents are complicated, right? Because that nice, fancy, gold-foiled piece of paper looks great on a wall. But if you can't afford to defend it, it's really not even worth the nice, fancy gold foil that's sitting on your wall that it's printed on.
Well, that's the thing. Very few people, despite what I just said in terms of like not releasing your product if you know a competitor has a patent. The fact is, there's no umpire out there who flies around and says, "Hey, you can't do this. There's this guy over there who's got a patent that's going to be infringed by your product."
Mm-hmm.
A patent doesn't sit there and prevent competition by any means. You have to weaponize it.
Yep.
If you know somebody's infringing your patent, you have to do the things. You have to send them the demand letter and hire the lawyers and bring the lawsuit and all the things.
It's not easy. It's why we work with.
It's not for the faint of heart, and it's by definition difficult for the little guy or little gal or little whomever to participate because it gets expensive really fast. And we see these clash of the Titan sort of disputes, right? Where Samsung and Google and Apple and Microsoft and all of that. And it's like, yeah, well, they can throw tens or hundreds of millions of dollars at litigation and even lose, and it's a rounding error. So
yeah.
Yeah.
If Facebook was just ordered to pay what, $78 million, I'm like, okay, here, write the check. No one gives a shit.
Yeah.
That's a rounding error, like you said.
Yeah.
One last question for you, because I know we are coming up on our time. Duff is asking, are there any benefits to registering patents, trademarks, etc. to a holding company and license it back to the operating company? He's approaching this as a construction company that could have all of its equipment owned by a different entity, but with patents, he doesn't know if that's how that works.
Really tough question to analyze in general because it's going to be very fact specific. I would say in general, I prefer simplicity over complexity.
It's
In
fair.
general, I would rather not you not structure your holdings to move intellectual property into a holding company that is then licensed back to the operating company. One of the reasons for that is that because lost profits are a factor in the damage computation. And it's the operating company that loses the profits on an infringement, but it's the holding company that has to bring a lawsuit. So the holding company can't necessarily claim lost profits due to the infringement because they don't have any necessarily.
Right.
So you have to be careful how you structure that. One of the if you are likely to be subject to being the defendant in the number of lawsuits, then it's a well tried and true a method of structuring your holdings to put each particular asset that could be risky in its own company. So, right, the apocryphal story here is that every different cab, every yellow cab on the streets of Manhattan is owned by a different company.
Mm-hmm.
So that if the cab gets in a car accident and the company gets sued, they can't touch the whole fleet. They can only touch that particular cab. Whether that's true or not, I've never actually verified, but it is a method that people use to isolate risk from profits. If you've got a line of business that is exceedingly profitable, you don't want it in the same company as a line of business that is exceedingly risky.
Correct.
And so separating those from each other and putting those in separate entities is always a good idea. So I'm not prepared to answer your question directly with respect to whether you should use a holding company right now. There are reasons for doing so. Just again on the keep it simple, stupid kind of philosophy. Investors don't necessarily like complexity. If you're looking for venture capital and you come to them and say, well, we've got this operating company, we're doing all this great work, and we're using intellectual property that's licensed from our holding company, but we're asking you to invest in the operating company, not the holding company. The investors are likely to say, hey, wait a minute, you don't actually own your patents? What is this license stuff? That's non-standard and therefore frightening. And so it can complicate your ability to do deals with that level. And I'm dramatically oversimplifying, okay? I mean, there are ways to get around that, and there are times when an intellectual property holding company is a good idea, absolutely, especially if you've got multiple different operating companies, all of whom can put the IP to different uses.
Yep.
But you're adding complexity to your life. You're adding different books, different accounting.
Different filings to three-letter
superhero
organizations.
CPA. You're going to do all the filings and all the things that have to happen every year to keep those companies alive, and tax returns and all the things. Does people do it every day? Okay, but it's very, very different from owning a solo practitioner or mom and pop, if you will, LLC.
Now, I've spoken with Duff, and I would say, Duff, where we are all at in our lives, let's go with no. It's not worth it for you. It's not. And I agree. Don't get it muddy, especially if you're looking to bring on, whether it's a financial partner or a partner for some sweat equity. Keep it simple, and then once you get your community of people, whether it's, VCs, lawyers, whatever it might be, then get together with them as a collective and make a decision of how you want to handle your assets, intellectual property, and all of that. Like, when we refile, we're going to be moving assets around in 3D Musketeers to get some assets away from 3D Musketeers, which can be inherently risky. We're selling them to another company that I own because it makes more sense to separate the assets of the company just from a liability standpoint. And because I need to insure some of these assets, and I can't insure them at 3D Musketeers because 3D Musketeers is not insurable. Yay.
Right. So there you go. So there's a good rationale. There's a good rationale for sort of asset allocation and diversifying the holdings, if you would, not really diversifying, structuring, hyper structuring the holdings in a way that makes things more tastier for people like your insurance companies. But again, if I'm investors counsel or buyers counsel, and I come to your company and we're doing due diligence because my client's about to write you a big check, one of my first questions is, show me what you own. Do you own your assets? Do you own your intellectual property? Do we have good title? Do you have contracts in place that get over that coffee table sculpture issue we were talking about earlier, where did you really own this, and do you have a good contract that says you do, and that sort of thing. And if the answer is, oh, we license all of our intellectual property from our holding company, I got red flags going up all over the place, right? At that point, it's like, okay, you're probably trying to pull a fast one here. You're probably trying to, deprive my clients of the full profitability of the intellectual property corpus that you own. And I'm more interested in that than this particular operating company. So again, now we're just having a longer conversation, which delays my client writing you a check, or perhaps even prevents it. Right. So
It's very true. Well, and you're doing a lot of interesting stuff now. You wanna tell us about what you started doing some social media stuff that I saw. That's when I said, hey, you should come on my podcast.
So thank you. As you've gathered, Grant, you put a microphone in my face or a camera, and I'm not particularly shy, but
No, we had a
I,
comment earlier saying that you talk more than me, which no one's
I,
ever said that one before. I said
I
that's
have
why I
a
like you.
pretty fast clock speed when it comes to the talking, and I apparently don't need to breathe very much. So,
No.
listen. I've been wanting to do videos online since YouTube was invented. And just needed, because it turns out, and this is one of the reasons I haven't been a particularly successful entrepreneur, is because I run a very busy law practice. It turns out I have a full-time job, and you don't succeed at entrepreneurship on nights and weekends. It turns out, if that's
No, you
all you
don't.
got, and you gotta own it. You gotta dive in and go all in. And so that literally what has been preventing me from doing videos and shorts and legal minutes and all these things is just I haven't had time. I've needed the right people to come along and own this for me, and literally just let me be the talent. Okay, put an X, tape an X on the floor, show me where to stand, and then say action, and I'll do the thing. But I can't be involved in this, that, and the other thing, and looking at the renting the equipment and all this stuff. And I've had a number of false starts over the years where I've gotten down the road with people, and there have been video footage created of me sort of walking, down the streets of San Francisco talking about entrepreneurship and all the stuff. And it just, I haven't been able to just make it happen. And it's my own fault because I haven't spun enough cycles on it. But again, I keep falling back on the issue that, trying to feed the kids with the law practice over here. So finally, I got good people. We at CoreX have great people. We got this guy named Chad Valentine, who's just been amazing. We hired a videographer for some of that footage that you saw, who did a wonderful job.
Yeah,
And there's more to come. In fact, I was going to drop a couple of things today, but I didn't want to compete with this. First of all, and second of all, the hurricane's coming, so I figured nobody's going to be checking their social media for a few days. We'll probably hit the brakes until next week.
I will tell
you. Expect to see more. No, expect to see more. I'm gonna try to do actually helpful tips and hints. I mean, it's all marketing. Let's be candid. It's all marketing. The whole point of doing all this is to, one, feed my ego, which is a hungry bastard.
I feel you there.
Number two, to drive business to my law firm.
God, I have to be public about the fact that I'm a YouTuber now, and it's just really weird. Because I'm like, okay, yeah, at more than 5,000 subscribers, you kind of have to mention it when you talk to people.
Yeah, you're an influencer now, dude.
No, I'm a content creator. Do not use that word here.
Okay.
God,
all right.
I hate the word influencer.
You influence me every day, Grant. So just want to
well,
thank you.
I will tell you, it is some of the most rewarding personally, but one of the worst business decisions I have ever made has been this YouTube channel. It has been a loss leader since day one, and I am now on my 3rd year of doing podcasts every single week.
That's the kind of thing that could just take off unexpectedly and do the hockey stick, and you'll be, it's a halting problem. You don't want to quit, right? Because it could succeed tomorrow. So.
Well, and similar to your field, right? We have all these questions here that to you might be very simple ones, but to guys like myself and the people in the comments, we don't know anything about this. And having a place where we can go to get that information makes you the thought leader. That's why we're doing it too. Because when a client says, well, how does this 3D printing thing work? Here's a video.
Yeah.
Well, what about 3D printing versus injection molding? Here's another video. Because that keeps me from doing a bunch of extra work, and then I can give you this whole plethora.
Absolutely.
And I've talked about it here before, something I would mention to you too. We are going to be doing paid classes soon online where we can pre-record it, right? It's not live. It's all pre-recorded.
Mm-hmm. Yeah.
It's deeper than what we give away for free on YouTube, and it's a good way for us to make a little extra money on the side for what is evergreen content, technically.
So here's something I'm gonna pre-announce. and only your listeners are going to know this. And it's not something I'm going to talk about for a while now, but it's just a little preview. I feel as though there are a lot of people out there who should call me who don't, because they don't want to pay me thousands of dollars, but they need to form a company and they need a little on-ramp into how to do this. And I'm hoping to put together a little SaaS, a little website, a little place, might be calling it the on-ramp. I don't know. I haven't done the trademark research yet. But where people can go to form their own company, get their documents that have been written by me and my team and approved and vetted, and do some cap table management and do some rudimentary legal work, print out an NDA when they need one, stuff like that. And so no specifics yet. We're right in the formative stages here, but at some point there will be a SaaS where you can go and do some things that you would normally pay me several $1,000s to do, for much less money, probably on a subscription basis, but a few hundred a year, and that'll be it. So,
as a small business, that would be something that I would love to see, because it's something that we could have used very early on. Like, I've got a very good NDA now. We leave pre-signed on our website for people to download and sign, because I just don't give a shit anymore. And it is one of those cases where having that legal team, having that assistance, knowing you when I had first started back in 2016, holy shit, I feel like I would have had a much better time than we did when we started. So, Brent, I've linked CoreX Legal and some other things down in the description for everybody. And of course, this will be live audio only in 1 week. So those that don't catch it live on YouTube will be able to listen to it on Spotify, Apple, wherever they do get their podcast. But seriously,
right there. All right, man. Grant,
I appreciate it.
It was entirely my pleasure. We all went almost 2 hours. I'm shocked if people have been actually sitting out there for an hour and 52 minutes listening to us ramble about this stuff. But thank you, everybody, for your participation, and thank you, Grant, for the stage. I always appreciate the opportunity.
Yeah, man.
To talk with you, whether we're on camera or not. So
anytime you ever want to come on, you are always welcome to be a guest. And
appreciate it.
I love working with you, buddy. It's
same.
Let's
everyone be safe. If you're in Florida,
yeah,
you do the thing. Don't hoard the water or the toilet paper.
And as always, everybody, stay safe out there. Don't forget to call your loved ones. And as always, keep making awesome. Have a good one.
I love that. That's good. I've been saying keep on innovating.
It's why it's called Making Awesome.
There we go. I love it. All right, bye, man.